record. Okay, now I'm not actually in Brisbane at the minute. I'm interstate, but for some reason my computer won't give me a video feed, but I'm told we can do an audio feed. So I can certainly hear, I've just been speaking with Terry, and there's a couple of other people online. So you don't unfortunately get to see me tonight. I know most of you will be shattered, but which is probably just as well because I'm dressed in holiday gear instead of business attire. So what we'll do is we'll work our way through problems 5 to 10, and it will be recorded. I can see at least I've got the recording going. If any of you got any questions as we go through these 5 problems, just chime in. Does everybody know each other online? I assume as much of you as wanted. Well, I can see Terry. There's one person who's joined whose mic seems to be off. That's okay. You don't have to. Yeah, hi. Who's that? Is that Lauren, is it?
It's Sarah.
Oh, Sarah. Hi, Sarah. I saw your name pop up before on the bottom. So that's good. Has everyone gotten onto the fact what I just said a moment ago, that we can't get a video feed, but we can get an audio feed, so at least we'll have, and you guys can of course hear me. All right, well let's have a look at question 6, and we're sort of getting into some of the meaty bits of judicial review here. Now, I take it, I hope you've all had a chance to look at the problem. It's not always the case that time-poor people get to do that. Now, I don't know if you've got the textbook handy, but I just wanted to, that is the Principles of Administrative Law by Kane and MacDonald. There was just something I really wanted to get our heads around collectively first before we look at the problems, because they have a really interesting fragment on page 37 of the book, which I'm actually going to read out for the benefit of those who aren't live with us at the moment. And basically, and really what they say here, and the thing I'll read out in just a moment, is a really good way of approaching a judicial review problem, both academically and probably for that matter practically as well. So if you've got the text, it's page 37 at about halfway down the page. All right, they say this, and it's really is quite a neat little summary. They say this: to succeed in a judicial review application, an applicant must satisfy a number of distinct requirements, and I'll number them. 1, the court must have jurisdiction to judicially review the impugned act or decision, and it must accept that the application raises, quotes, justiciable, close quotes, issues. Number 2, the applicant must be an appropriate person to bring the application. That is, the applicant must have, quote unquote, standing. Then 3, there must be a breach of an administrative law norm. That is, a ground of review must be available. 4, and the court must also have power to grant an appropriate remedy. 5, it must be the case that the legislature has not validly excluded or diminished the court's review jurisdiction. And they go on to conclude that by saying, in practice, these issues may be interrelated in various ways, but they sort of exhort or encourage us with this framework. So for us as people coming to admin law for the first time, it's not a bad little schematic at all, because what it does is it gives you an approach or a skeleton to use whenever you're thinking of a judicial review application. So you could do a lot worse than follow on what Kane and MacDonald say at page 37 of the text. So you'll have, of course, seen that on your way reading through, but at the start of doing some problems on JR tonight, we'll in fact look at that as a framework for approaching our problems. Okay, now what I want to start with then is problem number 6. And I'm just turning up my pages. All right, we've got this situation involving the mythical Mrs. Lang, and she makes a claim for compensation as a result of a DV incident, and her application for compensation is rejected by the compensation assessor on 2 grounds. And this is a mythical statute. I think somebody emailed me about that. There are Victims' Compensations Acts, but I don't think the Commonwealth has one from memory, or if they do, it's pretty attenuated. All right. So what we've got is we've really the question gets us to think about standing, and I'll just say a couple of things about standing, sort of to orient us a bit about this. Now, remember that basically administrative law as a whole is concerned with the relationship between the governors and the governed. In other words, we as citizens are the governed, and then you have the governors being the state, federal, or in the case of the territories, their governmental systems. So what we've got with this tension between the governed and the governed is we've got the fact that the governed can be affected by governmental decisions. And in each case, all legal systems do it differently, but under the Australian legal system, we have this requirement for what's called standing, or the Latin tag is locus standi. And basically, whenever you're up against a government instrumentality, if you being us as citizens, if we're unhappy about a decision, then we have to basically somehow demonstrate that we have locus standi, or if you like, the capacity to challenge a particular decision. So this question, problem 6, gets us sort of working and manipulating rules about standing. Okay, now our question focuses us on standing when it comes to the ADJRA, the Federal Judicial Review Statute, and we have two people who want to know whether they have standing or not. The first is Mrs. Lang's mother, and the facts tell us that she's outraged by the compensation refusal decision, and she's also outraged by the fact her daughter won't do it herself. We're told on the facts that she has paid a lot of money for medical expenses on her daughter's behalf, and she wants to be reimbursed. So she's paid bills on the basis that her daughter would seek compensation and repay her, and not only that, she is also caring for her. So that's the victim's mother. The other interested people are what we call the National Women's Justice Coalition, and they're equally concerned about the decision. And we're told that they were established to promote women's equality before the law, and they also have a particular concern about domestic violence. So what we have to then do is look at the rules of standing and see what we can come up with in terms of some advice for these mythical clients of ours. Okay, so just to sort of almost look at it in a practical sense too, what we also need to be aware of is that when people come across our paths in real life and we have an administrative law problem for them, in a sense, the very first thing you have to do as lawyers is to figure out, does your person get in the gateway, what we call standing, in order to challenge a particular government decision they're not unhappy with. Now, sometimes it's really quite easy, and a really simple example would be if someone was a Centrelink beneficiary and Centrelink stopped their payment for some improper reason, then there's no doubt that that person would have standing to challenge a decision. But here the problem is deliberately focused on people who aren't so directly connected, and it's those indirect connections that raise problems about standing. So it's not the easy ones that are difficult, but it's the cases on the margins that actually provide the difficulty. Okay, so what we first always have to do in an admin law problem is to figure out what is the decision we're unhappy with. So the first thing you would do if you were writing this as an answer to an exam question is you would identify in one sentence what decision it is that we're unhappy about. And in this case, it's the AAT's decision to refuse compensation. And there's no doubt that under Section 44 of the Administrative Appeals Tribunal Act that Ms. Lang has the ability to pursue her own matter. There's no question about that. So she could definitely appeal the decision to the AAT. So, but the question is the ADJRA, and of course that's a different forum. The ADJRA goes to not the AAT, but it goes to two other fora. One is the Federal Court of Australia and the other is the Federal Circuit Court of Australia. And in practical terms, most people, I think, tend to pick the Federal Court of Australia because it's got a longer history in judicial review applications than the Federal Circuit Court has. Okay, so what we have to do is look at the question of standing then and try and make some sense of what it is in this particular case. All right, so we can also clear the groundwork and probably assume that the Attorney General has not in either potential applicant's case, that is Ms. Leng's or the National Women's Justice Coalition, that the Attorney General isn't going to step in and bring the action on their behalf. The Attorney General can do that because the Attorney General is the first law officer of the Crown, and the attorney doesn't matter whether it's state or federal, but in this particular case, the Federal Attorney General would certainly have the ability to bring an action to challenge the legality of any government decisions, or particularly, lesser bodies. The other way they often do it in practice, they sometimes do it in practice, although you don't see it much anymore, is they bring what's called a relator, R-E-L-A-T-O-R action. And a relator action is where you basically sue in the name of the Attorney General about some governmental decision you're not happy with. In practical terms, though, you generally have to pay the attorney's legal fees if you want to use his or her name in an action. All right, coming back to our problem. All right, now the authorities that you really need to look at in this case are cases such as Australian Conservation Foundation and the Commonwealth, and also the subsequent decision in ONUS as well. But let's have a look at Mrs. Elder to start with. All right. Now, again, you have to figure out what is her relationship with the subject matter. And that is, we're told on the facts that she is the mother of a victim of crime, and she's on the two things are material on the facts. The first is she's outlaid medical expenses she wants to be reimbursed for, and secondly, she's also caring for a victim of crime. And the $64 question for us is, do those interests actually get us over the line in terms of satisfying a requirement for standing? Now, the standing rules, when it comes to the ADJRA, you have to take note of the fact that we are dealing with a federal statute, and the first thing you need to do is to figure out, does the statute itself have any influence or bearing on the question of standing? Now, if you have looked at the ADJRA in any detail so far, and you have, then if you look at Section 5, it has a requirement for standing that's expressed in the words, look at Section 5 sub 1, a person who is aggrieved by a decision to which this act applies, yada, yada, yada. So in other words, the statute expresses the requirement for standing in the terms that somebody has to be aggrieved. Now, in order to be aggrieved, it's suggesting of not just unhappiness with the decision, but it's a first order word that picks up a lot of secondary matters or consequences. So what we do have is we have the original case law from cases such as Boyson, Paddington Borough Council in the United Kingdom. That kind of started the ball rolling, at least in English administrative law, about the fact that when somebody is aggrieved about a government decision, there has to be some kind of connection or nexus between that person and the government decision. So Boyce's case started the ball rolling, and it started to articulate these principles about when people could or couldn't challenge government decisions. Now we don't, in Australia at least, we don't need to get too excited about Boyce's case, because the law in Australia has evolved beyond it. But the thing for standing in Australia really comes from the case you always need to discuss is the case Australian Conservation Foundation and the Commonwealth. And basically, that decision from 1980 basically says that you have to assert a private right that is directly affected if you're an applicant. So in other words, the example I gave before about a Centrelink recipient, if his or her payment was cancelled, that person would definitely have standing because they have a private interest, and that private interest is the right to receive a Centrelink payment. So there's no question about a private individual who's directly affected. In our case, so we've got Ms. Leng, who's in fact her mother, Mrs. Elder or Ms. Elder, she's basically complaining of financial detriment. So what we also have to do, beyond just thinking about the really basic rule about standing, now, the other thing you also need to keep in mind, and it came up in a lot of the cases involving environmental litigation, of which ACF is an example, you don't have standing if somebody is merely attempting to prevent a public wrong. In other words, if there was a thought that mining on Fraser Island was a bad thing, and most of us might be against the idea, then that kind of emotional interest or ideological interest doesn't get us over the line. So we've got what the rules of standing do is basically regulate access to justice. So coming back to our present example, we have to basically say or identify a basis on which Mrs. Elder may be able to have standing. Now, another thing to look at in her case, that is Ms. Elder's case, is look at Mason's decision in ACF and Commonwealth. And there, Justice Mason said a person has standing when he or she can show actual apprehended injury or damage to his property or his or her property or proprietary rights, to business or economic interests, and perhaps to social and political interests. So that sort of exceptional carve-out for social or political interests is quite interesting, because up until ACF and Commonwealth, it is definitely the case that a social or political interest would not have got you standing under Australian laws that previously stood either at common law or, for that matter, under the ADJRA. So what we have to do in Ms. Elder's case is we have to try and ask the question, can she show damage to her economic and social interests as a result of the compensation decision? Let's go back to our facts. We're told two things. She's paid for medical treatment for her daughter. She needs to be reimbursed. And also, she's effectively providing income support for her daughter. So the question then is, are those things sufficient to get her over the line in the sense of having standing? There is no question that she has an intellectual or emotional concern, but on the case law, that's not enough. What we have to show is that Ms. Elder has to basically argue that because of her extensive financial expenditure, the medical bills she's paid, and also the practical day-to-day care, that she has an interest going beyond a mere emotional interest. And also have a look at Gibbs's judgment in ACF and Commonwealth, where His Honour said, a person is not interested in the meaning of the rule unless he or she is likely to gain some advantage other than the satisfaction of righting a wrong, upholding a principle, or winning a contest. If the action succeeds, or to suffer some disadvantage other than a sense of grief or a debt of costs if his or her action fails. So in other words, even on the early embryonic understanding of standing that sort of came through the ACF case, we could probably get to the point where Ms. Elder does have sufficient standing, would be my thinking. So certainly she gets over the line. Now, another thing that needs to be borne in mind, practically speaking, is that whenever anybody challenges a government decision and they get past standing, the thing that is always going to be a potential downside to any litigant in the federal system is the idea that if you lose the action, you might be up for a cost order against you if the government department wins the case against you, or the case that you bring against it, rather. Okay, so all right, now the next thing to consider in this problem is really the situation of the National Women's Justice Coalition. Now, what we've got here, though, is, and again, we have to go back to our facts and see what they tell us. The facts tell us, yep.
Where are you getting this information about Miss Leng's mother and the Women's Justice?
It's in the problem.
I can't find it anywhere in the problem.
I agree, Terry. I can't find it.
Oh, sorry, it is in mine. Okay. Now,
there's no reference There's
Sorry.
no reference to it in the problem
Okay.
on
Yeah.
Google, and there's no reference to it in the problem in the notes.
This is in 6. Are we looking at 6?
You certainly are. Miss Lang's legs were broken.
Okay. All right. Okay. No, that's right. I know. No, I know what's happened. I've had a page interposed. All right. Well, we can stick with Lang, and yeah. Thank you for that. That's okay. No, that's right. There was something in another document that was whacked in front of me. All right. Just stick. All right. Well, that makes it a lot easier then. All right. Sticking with Lang, that is the mother. What we've got is then the situation where she does have standing because she actually is personally affected by this particular problem of having her compensation refused. Now, okay, actually I have a feeling that what appeared in the notes, your course notes, may have only been half the problem, because if you look at the end of the question, at least on the version I'm looking at, it says, consider whether either of the applicants would have standing to test the legality of the decision. So is that the one you've got?
Yeah, that's right.
Okay.
There's no reference to Miss Lang's mother or
Okay.
yeah.
All right. Okay, let's go. Okay, let's just go back to her personally. All right. Okay, I think the longer version of that problem that I was muttering on about before, yeah, I could be wrong, but I think something dropped out. Anyway, all right.
Just on the point about the women's league, Simon.
Yep.
Where the legislation says a person who is aggrieved.
Yep.
Does the term person include, the individual or an organisation? Because a person is not defined in that particular.
No, it's not defined in the statute. You go to the Acts Interpretation Act in 1901.
Yeah, so we are looking at the Acts Interpretation Act definition of person.
Yeah, that's right. And while I don't have that open in front of me at the minute, I've looked at it obviously several times over the course of my career, and I think it includes obviously corporations and artificial legal entities. So there's no question that Ms. Lang would have the capacity or standing to challenge the problem. So I'm just pulling out the other version of that problem. Okay, yeah, look, I could be wrong, but I have a feeling something dropped out. Anyway, so that means it's a simple problem. Okay, all right. Okay, just keep in mind that what I was saying earlier about the extended problem that you don't seem to have, that certainly is in my material. What that's doing is getting you to think about more difficult questions about standing. So on the example I gave before about Ms. Lang's mother, Ms. Elder, that does definitely raise questions of standing. And also this other interested body, this mythical, that you don't have, National Women's Justice Coalition, they again are another body, to use a neutral term, who is seeking to have an interest. So you can expect the questions in real life, and for that matter exam problems too, to be quite different to the very simple stripped down version of Ms. Lang proceeding with that. Okay, all right, well, sorry for that. Let's move on to problem 7. Okay, we've got this quote from Justice McEwen in Bateman's Bay local Aboriginal Council against the Aboriginal Community Benefit Fund. And Justice McEwen says in that fragment there can be little doubt that the present law on standing is far from coherent. So, in effect, we're asked to discuss that particular problem. Okay, all right. Well, if you had this as a problem in either an essay question in an exam or something similar, you obviously, in an essay question like this, you would actually start with defining your key terms. And the one that obviously screams out for attention here is the question of standing. So you could go to a legal dictionary and define it, or to the cases. There's it's been defined any number of times, but let's pick one case. The Right to Life Association New South Wales Incorporated against the Secretary, Department of Human Services and Health, which you'll find reported in 1995, 56 FCR. It's Federal Court Reports 50 at 63 and at 66, and look at Justice Lockhart's judgment. And His Honour said that standing refers to the entitlement of an applicant to bring proceedings before a court or tribunal and to obtain relief from such a body. Okay. All right, so at least that's we need to have a shared understanding of a term like standing if we're going to get into the other part of the question, and that is the question of coherence. Now, the idea of coherence isn't actually a legal norm in the sense that words like legitimate expectation or freedom from bias or all of those other sort of words that have a much more loaded or settled meaning. So we would probably, in answering this in an essay-style question in the exam, we'd also need to come up with at least a tentative definition of coherence. And and basically what coherence means is something is either logical or it's well constructed or it's well knitted together or consistent. So any of those kind of dictionary meanings of coherence will at least get us started. So what we need to do then is to then take those two ideas and take them back into McHugh's statement. And he says, his quote again is, "There can be little doubt that the present law on standing is far from coherent." So if you look at it from a micro level, you're looking at it in dissecting what is standing and what is coherence. Now, when you've got those understandings, you then need to sit above the thing, that is from a helicopter vision perspective. And what you then need to do is to say, well, really, what is the judge saying? And he's saying that the law is not unified, not logical, not structured when it comes to the question of standing. So a question like this then asks you to then go back to the case law and the decided examples and extract some notions about this question of coherence. That is it right? Now, if I was an examiner marking this particular question, it wouldn't bother me if you actually argued it was coherent, and it wouldn't bother me if you argued that it was, it either is or isn't coherent. The answer, in a sense, doesn't matter to me. What matters is the process by which you go about it. So just understand that to start with. All right. Now, if we come back to the notion of standing, what we have to get our heads around is that the rules on standing aren't uniform across different statutes. Just to come back to the ADJRA, if you look at Section 5, it uses this concept of a person aggrieved. So that at least gets us a little way down the track. It of course begs the question, when is a person aggrieved? And that comes back to what we were talking about before, and that is the notion of somebody having a sufficient personal interest in something certainly makes you aggrieved. So if somebody is directly affected by a government decision, stock standard example I use is somebody in receipt of Centrelink benefits has their benefit cancelled, then clearly that person is aggrieved by that decision and can challenge it. Now, there are all sorts of examples in the case law. If you look at that decision in Allan, that's ALLAN, and Transurban CityLink Limited in 2001 208 CLR 167, in some statutes, the test of standard is extremely broad. It's what we call an open standard, and it basically says any person. So in other words, you don't have to be aggrieved or upset at something, you simply have to qualify as a person. So where you've got a very open-ended, very open-textured question of standing expressed in a statute, then that's an open slather for anyone who wants to challenge it. Now, in terms of remedies, at least, remembering that the common law is so incredibly remedy-driven, if you look at the prerogative writs such as certiorari and prohibition, basically they also have a very generous test of standing. So they have an open test in the sense I've just described. And for the authority for that, look at that decision in Re McBain, ex parte, the Australian Catholic Bishops' Conference, that 2002 decision. Now, the other thing, though, just sticking with open standards of standing, is that sometimes if somebody is so personally disconnected from a government decision that they're not happy with, that can be a reason for the courts to refuse a remedy on discretionary grounds. And so you might win the battle but lose the war. In other words, the court might say, yes, we recognise that you, Ms. Smith or Ms. Jones have standing, but your personal interest in the case is so far removed from what it's about that as a matter of discretion, we're going to refuse you relief. Now, another, perhaps an example at the other end of the spectrum is if you're, a lot of the, what we call public interest environmental litigation that happened in the 70s, 80s and 90s. And you had a lot of groups like the Environmental Protection Defenders Office and things like that, and other bodies. And there were people trying to challenge decisions, usually in the environmental sphere. And although you've seen them, we see these also in the health sector too. Basically, you have to look at each legislative scheme and get a sense of what are its control elements. And if you've an example just to as a foil or opposite to what I was just discussing before with Alan's case is sometimes standing is restricted to those who are directly and adversely affected by a decision. So that's a very tight or closed system of standing. So where your statute doesn't really describe it in any sense, you'll see references in the case law and in the academic commentary to this this idea of what we call a special interest. And you'll see that phrase a lot. Go back to that case, ACF and Commonwealth. And basically, this idea of having a special interest is something that's supposed to separate somebody from the rest of the crowd in terms of do you have the ability to challenge that decision? That is the question of standing. So, and the what that example also shows is that if you also drive it back into the ADJRA, it basically, the test of a person aggrieved is pretty much swept up by this idea of somebody having a special interest. So if somebody wants to challenge a decision of a governmental agency, they basically have to have a special interest. So, and that's, if you like, your fallback or default position if your legislation doesn't have a different standard. So there are two rules to keep in mind here, everyone. The first is you look at the statute and see what its rule for standing is. And secondly, if it's not an open-ended or open-textured requirement of standing, then basically, at least courts in Australia will fall back on this notion of a special interest.
Can I ask a question there, Simon?
You sure can.
Well, on that point, if you've got a statute that has a very open standing,
yep,
but you seek judicial review under the ADJR,
yep,
Section 5 is a bit of a filter and require that it doesn't matter whether the enacting legislation has an open standing, you still have to meet the requirements of Section 5 to have grounds?
That's right. Stand? Yes, you do. That's right. And now that's a good question, Terry. You always have to go back to the person aggrieved standard under the ADJRA, because that's the thing that gets you the remedies under that statute. However, there are other statutes that have their own requirements for standing, and some of them are federal, but also particularly in the state domain as well. So if we go to another example, if you want one, is have a look at Section 475 of the Environmental Protection and Biodiversity Conservation Act 1999 in the Commonwealth. It's basically got a very generous or open standard of standing. So in each case, you've just got to look at each statutory scheme to see what it says. And your default one is if you're going in under the ADJRA, then you have to satisfy that statute's definition of standing. And of course, on the examples we just thrown around a moment ago, they're in fact two different standards. So the federal legislation statute a moment ago I referred to, that's got a very generous question of standing, whereas other statutes are much more limited. And the ADJRA is an example of a more limited one because it uses that idea of a person aggrieved. So the hallmark or the thing to help you to understand it all is that you have to look at each statute on its own terms.
So if you were launching an action under a statute that had a broad standing, and you knew you were going to get defeated by Section 5, you might choose a common law action to avoid the ADJR?
Yes, that's right. So in that case, you would go in under. You can either go in under the constitutional one, Section 75, or essentially, Section 75 of the Constitution has been replicated more or less in Section 39B of the Judiciary Act, and most people would start, if you wanted to step outside the ADJRA, you would go to Section 39B of the Judiciary Act, and you'd start your action in either the Federal Court or the Federal Circuit Court.
Yeah, thank you.
All right. Okay, now when we come to this question of coherency and incoherency, the other thing to bear in mind is that although we know the case law says you have to have a special interest, but it's easy to state the rule, but it's quite difficult to apply it in some cases. And particularly it's difficult to apply when you might be a person who's concerned about, let's pick a topical example, a decision to grant an exploration permit for coal seam gas. Now, if you're the landowner, no question you've got standing if you wanted to challenge it under the JRA, and I'm assuming the JRA in Queensland, for example, doesn't exclude exploration permits under the Mineral Resources Act. It's not a question I've looked at, but I'm just speculating it may or may not. But on the other hand, if you're a group concerned with, say, the welfare of farmers, what if you were AgForce or some other crowd like that? You may not necessarily have standing even if on the special interest test, because your connection with an individual decision to grant or refuse a coal seam gas exploration permit your personal connection may be so tenuous or remote that a court would say you don't satisfy the special interest problem. So what we've got is the idea of special interest is actually easier to state, as I said a moment ago, but problematic to apply in practice. So let's look at two cases where the question of special interest is seemingly similar but really different results. Many of us would remember that case, Western Australian Brofo, and you had the situation where I think Brofo wanted to protect something to do with some contested land in WA because he was a person of Aboriginal descent and he was a custodian of a particular site in accordance with the customs of his people. Now, in the other very famous case with similar facts, Onus, you had, again, Aboriginal plaintiffs who were the guardians of relics according to their local, Aboriginal laws and customs, and those things were held to give standing. So in Brofo's case, there was no standing according to the court, whereas in Onus there was. So you might think if you're looking at a system and trying to make sense of it, which is what this question of coherency is about, how do you justify the people in Onus getting up and Brofo not succeeding? So the point of their story is the question of special interest can seemingly have a very rough application in some cases. So in looking at this second problem, just the way to answer the question of coherency or incoherency is to look at cases such as the ones I've just spoken about, and you have to try and see whether they can be reconciled or not. And a few of the commentators certainly don't think Onus's case squares up very fairly with WA and Brofo. So that really is the situation involving the second, problem number 7. Now, just while everyone's online, I just have to go and flick on a light where I am now, otherwise I'm not going to be able to see a thing and you'll get even less benefit. So just excuse me for about 20 seconds. Okay, I'm back. Can you all hear me now?
Yep.
Okay, thank you. All right. Now, let's turn to question 8. Oh, sorry, any questions about question 7 before we move on? Just before we do move on from it, I just want to just say a couple of remarks about standing before we leave that topic. All right, now, you generally have to satisfy standing at 2 levels. When you're talking about constitutional judicial review, that is under Section 75 of the Constitution, you have to look at obviously what the case law says about what standing is, and effectively it's a question of special interest. Gets you over the line. When you look at a statute, for example, the JR in Queensland or the ADJRA federally, you've got a different express test, and that is it's a person agrees. So the take-home message is look at each legal regime you're concerned with, and see whether or not it expresses its own requirement for standing. And if, for example, you're dealing with an exam question that didn't say anything about it, then you need to look at the general principles of standing, and in particular, you need to look at the question of special interest. All right, Yep.
So what you're saying there is, even though you may have a special interest in a particular matter, if you're not aggrieved by it,
yep,
you don't have standing under ADJR.
Sorry, say that last thing. You have a special, even though you have a special interest.
Even though you may have a special interest in a matter,
yep.
If you're not actually aggrieved by that decision, you won't have standing under the ADJR.
Yeah, not quite. The way that the person aggrieved test has been interpreted under the ADJRA is that if you have that special interest, then you have standing and you can challenge it. So in other words, special interest is a synonym for being a person aggrieved. So the question of being a person aggrieved isn't that you might be emotionally upset about it, but that's not the test. The test is, do you have that sufficient connection expressed in the special interest test? So that's what gets you over the line if anyone wanted to challenge that decision. It's person aggrieved isn't the question of how emotionally distressed you are by a decision. You can assume most people are. That's why they're challenging it. So it's expressing a fairly an objective standard, not a subjective standard, about when somebody actually can activate that machinery. Okay. So that's the way to understand standing. Okay.
Yeah. Thank you.
All right. Okay. Let's shift on to problem 8. All right. Now I'm just going to pick up the other version of problem. Make sure we're on the same page with this one. Okay. Now, this is the one I've got is this the one that starts following several cases in which different authorised persons make apparently inconsistent decisions? Is that the one you've all got?
Yep.
about the Attorney General preparing guidelines. This is a sort of continuation of that Makepeace problem that we were introduced to right at the beginning. So we've got that one on the same page?
Yep.
Okay, good. All right. I assume everybody else is there too. All right. Okay, so we've got, so I take it where our client is Dr. Jekyll. Is that the one you've got as well in that problem? Just want to make sure that what's replicated in my material is the same as what's been online with yours. Okay. All right. Now, what we've got here is this question of guidelines, and it comes back to this question, and I'll just say a couple of remarks in general before we descend into the details. Many policy regimes work on the basis that there are guidelines about how certain things are to be done. And one of the reasons for guidelines is to ensure consistency and good administration. So in and of themselves, guidelines aren't a bad thing. But for administrative law purposes, the question is a little different. It has a different focus, and that is anybody confronted with a set of guidelines, the things we think about as lawyers, or at least, is whether a decision maker has got powers to decide something, and do the guidelines help the exercise of that discretion or power, or do they hinder it in the sense of constrict it or fetter it? So we're coming to some of those grounds of review that, things such as acting under dictation, not being fettered, and that sort of stuff is where the question is orienting us. All right, now, if we look at our facts, we've got this set of guidelines, and at a policy level we can understand them, but we've got a client who wants to import a particular work, probably influenced by D.H. Lawrence, but I could be wrong. And it's a prohibited publication, and we're told on the fact that some applicants got through and some didn't. And we have this situation where Dr. Jekyll is told by the authorised person, their name isn't given but it doesn't matter, says that they have considerable reservations about aspects of the research, and the rather cute comment about testosterone charged students reading this. So anyway, and then the advisor or authorised person explains their decision and how they came about doing it. Now, there's a couple of things that stand out in what the advisor says. I'll just call that person the advisor. It's easier than authorised person. The advisor says, in making my decision, I've been guided by several similar applications. In each case, permission was denied. Some of these cases were weaker than yours, but one was, if anything, even stronger. So in other words, the advisor has this habit or policy of refusing applications outright, whether they were stronger or weaker. Now, the question says of us, Dr. Jekyll wants to know whether she has any legal redress, and she also talks about this other work, Me and You, in order to calibrate a puriometer. I have no idea what a puriometer is, apart from possibly measuring prurience or standards of social degradation, but look, it doesn't really matter. Okay, all right, let's look at what our question asks us to do. We have to give her advice about the validity of the decision to refuse permission for importation of the work, and also which is Lovely Lady's Chatter, and then there's the other one about the Me and You work. And we're told to assume that the AG has issued a certificate precluding AAT review. Just be aware, in practice, the attorney can do that in certain matters, and that's under the AAT Act and sometimes other statutes as well. So sometimes the Attorney General can block merits review by bodies such as the AAT. All right, so when we have a question like this and we have these guidelines, the thing we need to think about, you ask as a general proposition, are the guidelines illegal or not? Now, to really answer that question, you would actually, in real life, need to know a lot more about the guidelines and the basis on which the attorney has made them. But you can assume for our present purposes that there's nothing indicating that the making of guidelines is illegal. So we work on the premise or baseline that which isn't said to be illegal is in fact lawful. It's like a bit of a dichotomy we use in the legal system. All right, so let's look at the guidelines, and what we are told are a few crucial things. Now, if you look at the guidelines 1, 2, and 3, what we're told is effectively they have to act according to the guidelines. That is, the guidelines must be consulted. And in particular, if you look at problems, guidelines 3A, B, C, and D, what we've got is almost a pathway that decision makers have to follow if they're going to actually make a decision about giving or refusing permission. All right, so let's just look at these guidelines in general. Now, the first thing I'd probably note is I'd go back to a very early case called Drake and the Minister for Immigration and Ethnic Affairs, number 2, and I would be making the comment that consistency is an element of good administration or good public administration. So having guidelines per se is no bad thing, the comment I made before. So you can't sort of tarnish guidelines just because they're said to be guidelines and they exist. So that's the first thing. Now, if you look at the guidelines, and we'll just work our way through them sequentially, if we look at number 1, it's a question about financial responsibility. There's no legal problem or error with that. If we look at number 2, where it says, in exercising powers under the subreg, authorised persons should consult the department's lists of permissions. That's basically directing decision makers to look at a list of where the permits have been given in the past. Again, that's no bad thing. That's not telling people how to do their job or not to do it. But let's have a look at number 3. Now, what we've got is the words, it starts, an authorised person should not normally, and underscore the word normally, make a permission decision which is inconsistent with a prior decision by the Attorney General or an authorised person. So again, what we've got is this idea that we might be straying into the domain of fettering discretions. Now, if you have a look at 3A, the prior decision was in the opinion of the authorised person contrary to the law. What it's getting to is the policy isn't purporting to exclude or preclude the consideration of legally relevant considerations, nor to mandate the consideration of legally irrelevant considerations. So the case to look at in this area is that Centrelink case of Green and Daniels, and you might remember that was a case where you had a situation where somebody, I think, qualified for unemployment benefit according to the then Social Security Act, and the then Department of Social Security had then adapted a policy where what they did was they actually added criteria to the statutory elements for getting what was then the dole. So it was that additional element that fell foul of the High Court. So what we've got is, and that was expressed as a guideline. So if you've got a guideline that is additional to what a set of rules is, or legal rules is, then you're going to come unstuck, and that's what Green and Daniels is about. Now, so what we need to think about with number 3A is and again looking at the whole thing in context, the decision maker who's looking at 3A is enjoined or encouraged not to make a decision inconsistent with a prior permission decision unless that prior decision was contrary to the law. So it's actually encouraging observance of the law, which is no bad thing. So you probably wouldn't put a black mark or a strike against number 3A. Now, if we look at 3B, it's saying prior decisions which, in the opinion of the authorised person, are inconsistent with each other. Again, that's coming back to a standard of administration which encourages consistency. So if the decision maker is allowed to ignore inconsistent decisions, then that's simply no bad thing. So that's all right. Now let's have a look at number 3C. It says the prior decision was, in the Attorney General's opinion, wrong. Now that should raise a red flag for you, because the decision maker is actually the authorised person. So if you have as this problem suggests, if the Attorney General thinks the prior decision is wrong, and the guideline then says that a decision maker can't make an inconsistent decision with that, what you've got then is a situation where an administrator or decision maker is now acting under dictation. So that's problematic. You would also probably look at Section 34A of the Acts Interpretation Act, and it says that where somebody is a delegate, then that person is to act on the basis of their own beliefs rather than those of others. So in other words, you can't act under dictation. So the real problem then with scenario 3C is that the guideline is fettering or controlling how the subordinate is supposed to make a decision. So there are problems with guideline 3C.
Right. Can I just ask a question on that one, Simon?
Yep.
Even though that has an element of fettering about it,
yep.
If you go back to, like, an unauthorised person should not normally make a permission decision which is inconsistent. So if they make a decision to permit the booking because the Attorney General's opinion another decision was wrong, doesn't that favour of the applicant seeking a permission? Because it's not excluding permission, it's actually granting permission because of inconsistent with a prior one.
It probably, ironically, would on a sort of the scenario you're positing, but the real vice with what is in 3C is that it's the subordinate is not independently testing the veracity or the correctness of the attorney's decision. So if the attorney says any situation where this happens, X is wrong, and therefore you as the delegate must make the same decision, the problem with that from an admin law viewpoint is the delegate has no capacity to independently review the decision to decide whether or not it's correct on its own merits. And that's the vice with the rule against delegation and the rule against, more particularly the rule against fettering discretions. So it doesn't really matter if it might actually perversely be a good outcome for an applicant. What we've got is if the carve-out in 3 doesn't apply, which is the opening paragraph, then you've got a situation of a decision maker actually acting under dictation because the attorney's opinion is that decision is wrong. Now, it then begs the question of, how do you investigate whether the attorney's decision is right or wrong? Ultimately, only a court can do that, and certainly decision makers can't. And that's the problem with these situations where you've got people higher up the food chain in government, purporting to dictate how people further down the food chain will in fact make decisions. So the rule against fettering discretions, everyone, is really based on this idea that if you have an inflexible rule like this, it stops each decision maker who has to make a decision from considering the merits of the decision on their own without being told how to do it. And I have a feeling that, and although I haven't looked at it closely in recent times, but some of these outlaw motorcycle law decisions, not just the legislation, but also some of the administrative decisions going alongside it, may also have a feeling fall foul of some of those principles too. I'm not saying I know of any, but I'm just guessing that that would be a pretty good area, contemporary area to consider it. Okay, now if we're going to look at problem 3C in slightly more detail, then we then start to inject ourselves into that area of law about acting under dictation. So the cases to have a look at are the Crown against Anderson ex parte IPEC Air, and also have a look at the Ansett Transport case as well. And basically what the High Court said in IPEC Air case is that the repository of a power is responsible for its exercise and must act independently of others, including hierarchical superiors. That point I made before. You're not bound by what people high up the food chain say you must do. So if a particular person or officer is entrusted with a function, he or she has to exercise it independently of pressure from higher up, is essentially what it is. But you always have to look at each situation on its own merits, and by that I mean you look at the question whether does the decision maker, are they taking advice from others, which is okay, or are they being told what decision to make, which is not okay? So that's like, if you like, the line between the two. The really interesting cases that are at the margins are, in fact, those where a decision maker, I think the two cases, ex parte IPEC Air and Ansett Transport cases, were about the importation of aircraft. And it's one thing for a decision maker who's deciding whether or not to give an import license. It's one thing for them to take advice on a technical nature. For example, what kind of aircraft is it? You might go to, the transport department or aviation or something like that and get specialist advice about whether the aircraft fits within or outside of the statute that might prohibit its importation. A contemporary example would be under the customs prohibited imports regulations about the importation of weapons. There are some things, whether something is a submachine gun or something like that, you might need technical specialist advice from the military in order for that person to decide whether or not to allow the importation of a prohibited weapon. So it's okay, the cases say it's all right to get technical advice. It's not okay to be told how to exercise your discretion. All right, so in answering this this problem, were it an exam question, you would certainly want to look at the question of acting under dictation. Now, let's also have a look at the other part of problem 8, and that is to do with the question of, she talks about this other book. She tells us she wants to import a book called Me and You in order to calibrate this mythical machine called a prairieometer, and we're told on the facts that the authorised person has already given permission to import the book, but it wasn't said to be relevant. So the question then is, what advice do we give her about that second work, Me and You? Have you got any thoughts?
Has he possibly not taken into consideration a relevant consideration?
Okay, and what relevant consideration would that be?
Well, the fact that other people have already been given permission to import the book, and
Sure.
he's just said that's not relevant. Well, without exploring that further, it could be quite relevant.
Yeah, that certainly is a possible way of looking at it. Certainly, the fact that the facts are a bit skinny, actually, to really, if this was a real life problem, the facts would be a bit skinny. It'd be hard to know which way to take it, because we don't know why some of the works were allowed and why some of them weren't. It comes back to this idea of consistency in decision making. But the question is, the prior success or failure may or may not be, is that a relevant consideration in making a decision? My view is it isn't. And the reason for my view, for what it's worth, is that whether import decisions are allowed in one case and not in another, even for the decision maker to say that's not relevant doesn't really take it all that far, because we simply don't know enough on the facts to indicate whether the criterion separating those two categories is something that we can actually use. And I think, Terry, you might have mentioned a moment ago the question of taking into account irrelevant considerations. Now, we know it's a grounded review under Section 5.2a of the ADJRA. We know that a decision can be invalid if a decision maker takes into account an irrelevant consideration. But here we've got the decision maker, if you look at the facts, he says that past success or failure is irrelevant. In other words, he's actually, he or she, that decision maker, is actually not taking that into account. And given what little we know about those two other situations, it's probably right. It might be different if, for example, the facts were different. Let's just change them slightly. So to import this me and you book, if the facts said that every feminist researcher was refused permission, but every let's pick another crowd, every Marxist was allowed to import it automatically, then whether you're a Marxist or a feminist isn't a sensible reason to allow or refuse the importation of a work. So that would be taking an irrelevant consideration into account, therefore the decision would be bad from a JR angle. But the facts, the bare facts as we have them, don't give us what I would call a criterion of reference or distinction to enable us to separate the two categories. So the answer is we just don't know. And indeed, even in real life, you may not know unless you maybe did a freedom of information request and got hold of the decisions in all those other cases, and then you can start to figure out what were the criteria used to allow it in one case and refuse it in another. So that you'd have to make an FOI request, I think, in real life to try and get hold of the reasons for the different treatment in two different cases.
Sorry.
Yeah, no, go on.
On a similar vein, a little bit earlier in that problem, it says, in making my decision, I've been going to several similar applications.
Yep.
In each case, permission was denied. Some of these cases were weaker than yours, but one was anything stronger. Should they take into account the other cases, or should each case be dealt with on its merits?
The answer is yes. Each case should be dealt with on its merits, but you've got a situation here where that fragment hints at the decision maker acting under dictation, because the problem goes on to say, I've also spoken to the AG, who has made his views only too apparent and who has regularly issued certificates precluding AAT refusal. So in other words, there's this idea that all what comes through from those facts is that in all the several similar applications have all been refused. The fact that some are weaker or stronger, we don't know the criteria why. They're just not unpacked for us in the problem. But one thing that is clear from that fragment of the of the reasons given by the decision maker is that clearly that decision maker is acting under the views of the Attorney General, which is the acting under dictation problem. So that's probably enough to knock out anything that really rests on particularly Guideline 3C. So what we've got is probably a situation where at the end of it all, the guidelines are probably valid insofar as 1, 2, 3, A and B are concerned. I wouldn't have a problem with 3D because a duty to consult is not necessarily a bad thing, but I think Guideline 3C is bad because it's acting under dictation, and so if you took it up under the ADJRA, you would probably succeed. So that's the advice we'd have to give Dr. Jekyll. Now, if we I just want to, if everyone can pick up the section 5 and 6 of the ADJRA, and in particular, when it comes to section 5, you could probably have a look at that particular guideline in the light of section 5 sub 1, and you might look at para E, improper exercise of power, and then if you look at 1E, you then look down at sub 2, and also section 6 sub 2. So I might just have to turn that page over. Sorry, just give me a tick. Okay, and if you have a look at section 5.2 sub, sorry, I just had it there a moment ago, sub F, the exercise of a discretionary power in accordance with a rule or policy without regards to the merits of the particular case. So in other words, you could attack Guideline 3C under section 5 sub 2 para F. And if you wanted to look at section 6, you would also have a look at section 6 sub 2 para E. And also sub F in that same section. So section 6 2F as well would be what you would need to look at.
Can I ask a question about subsection 6? Well, we're just about right.
Yep.
When a person is engaging or proposes to.
Sorry, this is 6. Sorry, this is section 6. I just missed the start of that.
Oh, sorry. 6 subsection 1.
Yep.
The person is engaging or proposes to engage. If you're seeking an action against something that hasn't happened yet, are you looking for an injunctive remedy there? Or not?
Yes. Yeah, and probably yes, you would, because the injunction would be the thing that stops the decision maker from proceeding. Yep.
So you'd have to have fairly good evidence that the decision maker was actually going to do what you are claiming they're going to do.
A good example would be, and there are, I think, quite a number of cases where a decision maker, say there's somebody says there are many regimes where you have to communicate a decision and the decision doesn't come into effect until 28 days later or something like that. So the decision maker will say, I'm proposing to do X, Y, Z. Let's pretend it's infected by legal error. And then there's a 28-day period or hiatus between the notification of the decision and when the decision can actually be implemented or put into effect. That 28-day period is when you would race off and get your injunction.
Yeah, okay. Cheers.
Yep. Okay. Doesn't happen all that often in practice. Usually decisions are what we call self-executing. So the decision maker makes the decision, notifies the person affected, and then you're not relying on your ability to, the injunction would be quite different. It might be maybe stopping them from implementing it further would be one way of dealing with it, or taking steps to actually carry other parts of the decision into effect. For example, taking property away or whatever it might be. So it depends on the practicalities as to whether you get an injunction or not.
So is that like a statutory answer to prohibition?
Yeah, the answer is yes. The statutory orders for review under either the Queensland Act or the Federal Act, what they were designed to do was to free up, to liberate the old prerogative writs from some of the restrictions that affected them. And so really the courts, basically, we say it all the time, but they shape the remedy to suit the circumstances. If you don't need an injunction, that's fine, but you might need an order from a court declaring a decision void because it's infected by one of the grounds for review. It's tainted by an error of law.
Yeah.
And that is often enough. Just the mere declaration that the court says the decision of this decision maker is invalid on its face. It doesn't happen often, but just to use that example, then that's enough to kill it dead.
Okay.
All right. Let's move on to problem 9. Okay. Now, just so we're all on the same page, this is about the press release. You've all got that? Just want to make sure my paperwork's the same as yours.
Yep.
Okay, good. Because I haven't got up on my screen at the moment the problems. I've just got the paper-based version rather than the ones that appear on the website. Okay. All right. Now, what we've got is this press release issued by the Minister, and it concerns the extensions of applying for Compo. And then we have Alexis Andropov being injured, and Alexis seeks an extension of time in which to make his application for compensation. So he sat back on his hands, did nothing for a while, and then he applies for this extension. All right. Okay, now what we have to do is look at what the question directs us to say, and it says really twofold. What arguments could Mr. Andropov raise in support of an application to set aside the decision to refuse an extension of time? And what arguments might the director use in reply? Now, the question is helpful in that it tells us what approach we need to answer it. Generally speaking, though, if we were doing this as an exam question and there was no advise X and advise Y, you would always consider the competing arguments, because if somebody's going to have a right to a statutory order for review, for example, you also need to think about, well, what can the opponent say against it? So you would always argue both sides of the debate in coming down with advice. And that applies to any lawyer advising. So you would always look at both sides of it, is what I'm getting to. All right, let's have a look at what Mr. Andropov might say. All right. Okay. Now, are there any interesting facts about the relationship between the Minister and the Director that Mr. Andropov might be interested in?
You mean like dictation?
Yeah. Look, if we look at the press release and look at the paragraph before the first paragraph, the Minister today announced he had recommended to the Director, etc., to adopt these policies. So, Terry, you've just flagged that it might be a question of acting under dictation.
But the Minister has a right to change policy.
They certainly do, and they frequently do. All right, so is that now? Let's look at the policy, we're given four features about it in those particular points. Now, if we look at the later facts, all right. Now, if we look at the minister has set this policy out, and what has the director done about the policy? Has the director applied it in accordance with its terms, or has the director departed from it?
The first one leaves a lot to be desired.
You mean the bit about the crime not being sexual assault, domestic abuse, or child abuse? Is that what you're talking about?
Leave will not be granted unless the applicant establishes there is good reason to do so. One could argue that he might be able to establish there's good reason.
Okay, all right. Okay, so let's look at. Let's stay with that point for the moment. What were the circumstances under which Andropov was injured?
Right, he's resisting an attempt to hold up a government-owned post office. So
all right.
Exactly. Maybe, you might argue he was doing a moral or social duty at the time.
Yep.
Which I would argue in his favour as a fine, upstanding citizen.
Yep. Now I'd go along with that. I think if we look at the first ground from the director, the director says it's not a crime involving sexual assault, domestic abuse, or child abuse for which you do ordinarily get an extension of time. He says was a crime for which extensions are granted only in exceptional circumstances. He says no relevant circumstances exist in your case. Would you argue with that factually if you were representing Andropov? And if so, what would your argument be?
Well, I would say that there are relevant circumstances because it says, however, leave will be refused only if the director is satisfied there are good grounds for doing so. Yep. I don't know whether there are grounds for refusing the leave.
Yeah. I think if you look at the first reason the director gave, you've got a very perfunctory dismissal of Andropov's argument. He says no relevant circumstances exist in your case. There's no sign whatsoever that the director has actually looked at Andropov's circumstances in any great detail. So that is certainly problematic. That is certainly problematic. Sorry, you had a question, Terry?
Oh, I'm just curious as to, does it fail for the sake that it wasn't reported as a crime? Therefore, does it even come into consideration as crimes compensation? Is it a crime because of the action? Is it offence or is it a crime only once there's been someone charged with the offence? Do you know what I mean?
Yeah. The degree of proof somebody would need really depends on. Well, if it's like all the victim of crimes legislation I've dealt with in the past, you generally actually need a conviction. So somebody under the victims' compensation laws, as I understand them in Queensland, and this is departing from this script a bit, you actually need somebody to be convicted of a crime. So the police have to have gone through all their normal processes to get somebody indicted and then charged, tried, and convicted before the compensation rules kick in. So in real life, you would actually have a conviction.
And which, to me, in this case, that that doesn't apply here because there's been no conviction of a crime
Yeah.
in his second.
Well, if we look at the policy and the fourth thing, leave will not be granted in any case to which the victim did not notify the policy of the offence, the police rather, of the offence within 6 months of the injury. So there's, if you like, a limitation rule built in. And you then have a reporting requirement that is not met. Now, we're not told enough on the facts whether that's consistent with the law or not. That is, other laws, e.g. victim compensation laws. But we certainly have this this question of the leave being excluding. Now, the other thing to also keep in mind, everyone, is this policy seems to be, does it have retrospective effect? Is a question, something you would need to advise on. That is, does it apply to anyone who is injured in the past but hasn't claimed, like Andropov, or does it only apply in the future? So one of the skills of lawyering that we need to get our heads around in this case is any way we can basically say, well, the policy is what it is, but it only applies to anything happening after today, the date of announcement of the policy.
Is there anywhere there where it says where his injuries occurred before the introduction of this policy, though?
No, it's actually, I think the problem is deliberately vague. It's trying to get us to argue that point. So if I was representing Andropov, I'd be saying the policy's fine, but it only applies to injuries after today.
Because that was my first question.
Yeah.
What was the policy at the time when he suffered the injury?
Well, we're not told what the policy was there at all. So we can assume there was no policy at the time, and the reason the policy has been introduced is to probably tidy up some administrative problems, which is what the very first sentence of the problem says, following criticisms of alleged inconsistencies regarding the granting extensions of time, etc., etc. So the policy is introduced to remedy an administrative problem. You can't complain with that at one level. But if I was in for Andropov, I'd certainly be saying that there's no suggestion that there's no proper suggestion that the policy has retrospective effect to his case.
Very inflexible policy guidelines.
Yeah, well, that's the okay. And in real life, we either would or wouldn't know whether those guidelines were consistent with legislation or not. Now, remembering we're dealing with judicial review here, so it's not as if there's a QCAT who can review this decision. They might come to a very different decision to what the minister wants, whereas we're focusing here on judicial review at the moment. All right, so the first thing, if we're acting for Andropov, is we would complain about number one. The director doesn't seem to have taken into account relevant circumstances, which are namely the public-spirited occasion on which Andropov was injured. So my view is that the director has not taken into account a relevant consideration. Now, let's look at the second reason, which is the expiry of the limitations period point. All right, now, what we've got here is a roadblock put up by the decision maker, who basically says that Andropov is too late because he didn't actually independently, as a civil private matter, a tortious matter, pursue a claim for negligence or assault against the wrongdoer. So the question, though, is allowing for that. How does that fit into scenario number two, or the reason number two?
There doesn't seem to be a lot of room to move with that particular policy statement.
No, no,
These are not examples in any case, but it's only a policy statement. It's not law.
no. And again, we're not told what the other law is, but if in real life we knew that the limitation period under the Limitation of Actions Act in Queensland was, say, 6 years for this. Again, we're not told quite when he was injured.
But I would argue that, on the good social citizen side of it, the reason he didn't notify earlier was because at the time he was being almost philanthropic and saying,
Yeah.
well, I don't need it right now. The money could be spent better, but now my circumstances have changed. I would argue that point against the time period.
Yeah. Yeah, I think it's a question of a policy being applied quite inflexibly, and again coming back to the JRA type statutes, and don't forget, of course, the Queensland one is pretty much a mirror of the federal one. You've got a situation where, if you look at the grounds for review in section 5 and 6, you might have a situation where so I'm just trying to find the right one. Maybe section 6, sub 1, para H. No evidence other than material to justify the making the decision. In other words, the limitations period point might be a complete furphy, for all we know. Also, 6.1e, an improper exercise of power. Again, the idea is that really this director seems to be acting under dictation. And also look at section 6 sub 2 para F, the exercise of a discretionary power in accordance with a rule of policy, and this is the vice, without regard to the merits of the particular case. So they're the sort of things that if I was in for Andropov that I would be arguing on his behalf. All right. Okay, we're also told now, sorry, the other thing is look at the policy as a whole and then look at what the director's done. Is there any suggestion here that the director has gone beyond treating it as a policy and almost treating it as a binding instrument on him? Is there anything, do the facts kind of suggest that? Yeah, there's a hint of that actually, because really what he seems to have done is just blanketly applied the policy and hasn't looked at the individual merits of Andropov's case. In particular, we noted that with number 1. So, and that takes us back into section 6, sub 2, para F, the one I mentioned a moment ago, the exercise of a discretionary power in accordance with a rule of policy, and this is the vice, again, without regard to the merits of the particular case. So in other words, there's a suggestion in this letter from the director that really it's just a carte blanche application of the policy, almost treating it like a piece of legislation, and hasn't looked at Andropov's circumstances sufficiently sympathetically. All right, now, are there any other grounds of judicial review that we might argue in favour of Mr. Andropov before we move on to the director?
No.
Okay, I think there might be 2 more just to note in passing. Okay, the first one I would note is that the director seems to have has not taken into account relevant considerations. And a good example of that is number 2, the reason number 2 in the director's letter. All those things about the offender, vendor not having resources, blah, 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 all those things are basically, they're actually examples of irrelevant considerations being taken into account. And the one that is relevant is the question of the limitations period. So what is really what I would say. Makes no difference. So there's probably 3 or 4 different grounds that would actually justify or support Andropov's argument about getting judicial review of this particular application. Okay, let's look at the director. What can we advise the director, remembering that every time we're giving somebody advice on one side, that we'll always have to think about the other side. There's this wonderful maxim in this area of law called audi alterum partem, here the other side. So we also need to consider what the director might say. All right. What can we say in the director's favour or in support of what it is? What can we say about the value of the guidelines or this policy?
The time frames might be justified on the basis that there's got to be some sort of closure on these instances. Otherwise, you could have people coming, like if Alexis' financial position change in 20 years' time,
Yeah.
and he come back and say,
Yeah.
change now, there's got to be some finality to the avenue of compensation. So time frames are a reasonable way of handling that in these situations, perhaps.
Okay. All right. So there's certainly an issue of time, in the sense you've just described. All right. Now, what about the wisdom of the policy as a whole? What would the director say about that?
He doesn't seem to support it too.
Sorry, I didn't quite. That wasn't clear. What did you say, Terry?
He doesn't seem to support it too strongly.
No, that's true. He doesn't.
No.
Okay, so that's really an internal problem between the director and the minister, and that director wouldn't be the first person who would ever have had a problem with a government minister. I can certainly assure you of that. You could probably tell your own stories too. All right, now the thing about the policy favouring it is that it's just that it's a policy. Are there any legal problems with having a policy that guides how decision makers are to make their decisions?
If the policy has been subject to scrutiny,
Okay. Yep.
then the governments have the right to put their flavour on how they see stuff interpreted. So if it's just an ad hoc policy, but if it's a policy that's gone through parliamentary scrutiny or scrutiny at least by committee perhaps, then it may be a sound policy to ensure effective administration.
Okay, well, that's the thing that obviously favours the policy as an instrument. All right, so what do we make of the fact that we've got a policy here that says what it says? What do we, allowing for that, what do we make of the application of the policy in this case? Now, remembering that we're trying to justify it if we're looking at the director's arguments.
Okay, if we're trying to justify it, then I'm not good, because I'm looking at the policy and think if this is all about victim crime. It seems to be a very harsh policy against victims of crime. Seems to go against them rather than for them.
Yeah, well, again, we're not given much of the other legislative scheme that it sort of sits beneath or behind. So there's an absence of knowledge on our part. But what we've got is, given what we do have, are there any other arguments that we can use to support what the director says? What about the fact that the director says he's taken into account, he says, taking account of the matters raised in your letter, I've decided to refuse application. So is there any suggestion that the director has not considered Mr. Antropov's personal circumstances?
Well, no, it looks like he's addressed the issues raised in the letter in accordance with the plan.
Okay, so there's at least not this naked idea that he's completely ignored him and made a decision irrespective of any submissions put to him. All right, so at least to that extent, the policy is working. The director is looking at somebody's circumstances in order to make a decision about whether to refuse or deny an extension of time. Now, that's a different question, everyone, to whether we agree the policy has been properly applied or not, and whether it can be challenged legally. It's almost like getting into the merits of the policy, which isn't something courts can do. All right. Okay, so just from a policy angle, what is the benefit then of a limitation period? What does it do for good administration?
A finality, if nothing else. It brings some degree of finality to potential claims.
Yep. Yeah, it's from a public administration angle, if there were no limits at all on applications, then potentially the state of, or whichever state it is, the state of Queensland or whomever, would have a very long tail of claims to deal with. That might, I think you might have used the example before, Terry, of 20 years in the future having to face claims. I think though, if we balance up the two sides of it, that is the director versus Antropov, I think the real vice with the policy is actually its retrospectivity, because it's being purported to being applied retrospectively, and there's this kind of legal principle. It happens not only in admin law but other courses too that you'll encounter, where basically the courts don't like applying legislation retrospectively. So it has to be very, very clear before laws can be applied retrospectively. And the same kind of thinking will also come in to this case that we're looking at, where it'll be said quite strongly, if I was arguing for Mr. Andropov, that the policy shouldn't be applied retrospectively. It can certainly be applied prospectively, but not certainly retrospectively. So I think if you balance all that up, even though we're not asked to make a decision one way or the other, but I think if we look at the spirit of the problem, I would probably think that the policy would be an inflexible application, would be being inflexibly applied, and it would be struck down the decision would be struck down under JR review, under judicial review to be more exact. All right, I'd like to move on to problem 10 before we wrap up tonight's session. Okay. All right. We've got the same take. We've got the same problem about the ancient religion of Gar. We've got the same one.
Yep.
Yep. Good. Okay. All right. Now we've got three questions to deal with. And again, the background is the importation of potentially prohibited objects. And the first question is, would the AAT, the federal court, or it should really read now, the Federal Circuit Court be likely to hear the application? Secondly, have any error of laws been made in the decision to refuse importation? And thirdly, aside from judicial review, are there possible alternative causes of action by which Wycliffe might press his claim? All right, so let's have a look at the first one. This is the question of what is the appropriate forum for the application. Okay. All right. Now, we're given three bodies to look at. The AAT. All right. What does the AAT do, everyone?
Merit review.
Okay, merit review. All right. Now, is there any suggestion on these facts that the AAT has merit review?
Isn't it precluded by the AG certificate?
It is. So that's basically kills that off quick dead. Okay.
We need an error of law.
All right. So rather than merits review, we now need a question of judicial review. All right. So we've got the Federal Court or the Federal Circuit Court. All right. What do we need to show to basically get either of those two courts interested in the matter? Remember that schematic I read out right at the beginning?
So we need an error of law?
Yeah, we do, but even before then, what do we need to establish?
Standing?
Exactly. All right, so does Wycliffe have standing?
They're a person aggrieved by an administrative decision, aren't they?
Yep. All right, and does Wycliffe have the requisite interest? I'm using the word interest in a very broad sense. Does Wycliffe have the requisite interest for seeking to import these religious artifacts?
I'll go out on a limb and say, yeah.
All right, well, the facts, let's go back to the facts because in the end they control what we do. We're told in just before the end of the second paragraph, he, meaning Wycliffe, wants the statutes for private devotional purposes. All right, what's the test for standing? Unless the statute provides a different one, what's the default general law question of standing?
Special interest.
Okay, all right. So then we have to marry up the facts to the legal standard. If the legal standard is you have to have a special interest, and the facts say he wants the statutes for private devotional purposes, does Wycliffe have the requisite special interest to get into the legal system?
Oh.
What do some of the decided cases say on sort of analogous sort of stuff? What about Onus's case? You know, the Aboriginals who were the custodians of land who were upset about decisions?
So he's got special interest because of his religious beliefs in this case?
Yep. And certainly on the authority of Onus's case, that's enough to separate you from the great unwashed, where they might not have a particular interest in it. So you probably would use cases like Onus in particular. That's probably the best one. And also Ogle and Strickland. They would be the cases. Sorry?
What was the priest one again?
Yeah, I think that's Ogle and Strickland from memory, but don't quote me on it. But yeah, it's where somebody has got a personal involvement in a religious system such that they want, they're just not some person from the back of beyond who has some remote intellectual interest. He says he wants them to provide for private devotional purposes. He's also a pastor of this Church of the Free Spirit. So he's got enough. There's enough evidence to suggest that he's got this special interest. So I would probably think that he would satisfy the the requirement for standing. All right. Okay, now, what else are we told on the facts that is critical to his ability to access justice? If you look at the final paragraph, are there any critical dates?
Leading to finish on 24 December. No, I'm missing it.
Okay, it's tied in with the fact that reasons are furnished on the 24th of December, and then a month and a day later, Wycliffe's solicitor seeks your advice. I guess we're the mythical counsel, advising on prospects of an appeal or something. And so we've got this problem about the time. All right, so if you look at section 11 of the ADJRA, it does in fact regulate time in which to make applications. Section 11 talks about 28 days.
Oh, okay.
Yeah. Now, it's not your normal general law limitation period of, 3 years in the case of a tort and 6 years in the case of a contract. You've actually got to move fairly quickly to make your application for review.
Does it make any difference that there's all the holidays in there?
It can do in some cases. That's a good question, because I think the Acts Interpretation Act says that if a date falls due on a public holiday, then the date for doing the act is in fact the next day. That is not a public holiday.
And some of the places to lodge could be closed over
Yes,
Christmas.
yeah, that is true. Although, just practically speaking, just about all courts and tribunals have arrangements for lodging documents urgently, even when they're officially shut. You can even get a judge up at 3 a.m. in the morning if you need an urgent injunction done by telephone. It's been done before. So you can really get into the system if you really, really have to, but we're told on the facts. Sorry, go on.
You don't want to appear before him again soon, then either, do you?
Yeah. Actually, I haven't done one by Zoom or Skype yet. That's interesting. All right. Let's see how that goes. All right. Certainly done them by telephone.
If we
Okay.
take a few public holidays into account, we might still be within the 28
Yeah.
days.
Let's pretend we're not. Let's pretend the holidays are against us, that we're outside that time. So we really require the favourable exercise of a time extension.
Well, we can seek it.
Yeah. Well, if we look at section 11 sub 1 para C, it actually sets out the time rule, and but it also says, or within prescribed period is 28 days, or within such further time as the court concerned, whether before or after the expiry of the prescribed time allows. So there's judicial elasticity to actually extend time. So if we look at assuming that the 28 days is strictly gone, then what is a court likely? What are your arguments if you were trying to persuade a court that you should have an extension of time in which to make your application for review?
That it was that time of the year and they were closed, or you couldn't get into your solicitor, they were closed to get legal advice?
Yep. Yeah, and I think given that courts are fairly keen to allow people to have access to justice, you would probably find that it'd be a pretty harsh judge who would not give an extension of time for this time of year. With Christmas, and that sort of thing. Notice also that Wycliffe is a religious practitioner of sorts. He says on the facts that Christmas was his time off. I would think even some of the hard cases up there at the federal court and the federal circuit court would probably give the extension of time. Now, the other thing to keep in mind too is that he's also not very late. He's only a couple of days late, 3 days late on my reckoning. So, if he's only 3 days late, what are can any of you think of the arguments that the Commonwealth government might argue against given an extension of time? What's the one? Anyone think of what the usual reason they throw up for opposing extensions of time?
That they know it's 20. Oh, he's got the 28 days, and so he had time.
Yeah, that's the first thing they would say, and the second thing they usually say is that we are prejudiced by the delay, and then a court would put the screws on the Crown's advocate and say, how are you prejudiced by 3 days late at this time of year when your client department wasn't even at work, or something like that. So I could pretty much see that the extension of time would be readily given. But always be alert to it because they're often very important in practical terms. So that's one thing you need to keep in mind. Now we've just talked about the ADJRA in Section 11. If we're going under the Judiciary Act, Section 39, there's no actual time limit there. So if we were late and precluded under the ADJRA, the alternative is to make an application under the Judiciary Act, Section 39B, and there's no time limits per se there. So if we were caught out on one, we try and run around it on the other side. Okay, all right, now that's the avenues of review. Can any of you hazard a guess as to why you might go to the Federal Court or the Federal Circuit Court, or which of those two you would go to?
I would try.
One that's going to give you what you want.
Yeah, well, both of the courts can give much the same remedies. The thing that might make a difference is actually the application fee. The Federal Court will be higher than the Federal Circuit Court. So if your client is poor or poorer, then you go for the forum where the application fee is actually lower.
Why can you start? Why can you commence in either court? Why don't you have to go to the inferior court?
Why don't you?
No.
Because that's a good question. The reason you don't have to go to the inferior one is that they've both got coordinate jurisdiction on it. Sometimes what happens is you can start something in the federal court and they think it's not important enough and they'll kick it downstairs to the Federal Circuit Court. That happens often enough. And
Does that go against? Does that go against you though? Like if you're, for want of a better term, bold enough to go to the federal court without going through the circuit court, and then does that go against you for not going to the inferior court first?
Sometimes you go to the higher court because you might get a better quality of judge up there, and I'm not being disparaging of Federal Circuit Court judges. I appear in front of a lot of them and they're perfectly good. It's probably can depend. Well, all the judges are always available, at least in theory. You'd probably go to if I was advising Wycliffe, I'd probably go to the Federal Court and see whether they remit it to the Federal Circuit Court for any reason. So at least there's no dispute about it being within jurisdiction. So all of the federal courts have jurisdiction conferred on them. None of them are automatic except for the High Court. So you'd go to the federal court and see where it goes.
So you'd go federal court first, not the circuit court.
Yeah, I probably would. Yep. And that is, if the federal court's going to remit it to the Federal Circuit Court, let them do so. And I've had cases where that's happened in various matters. Start off in the federal court and they think it's not important enough for them, so they kick it downstairs.
Okay.
Not very good from a justice perspective, but at least you're in the system.
So you just find a better model of justice.
Yeah. In theory, you get a better branded judge upstairs in the federal court than you do in the federal circuit court.
I remember that when you became a
Yes.
magistrate.
Yeah. Okay. All right. Let's look at the legal errors. The second problem. Have any errors of law been made in the decision to refuse importation?
I'd try what they define prohibited import as.
It's probably that very first problem we have. It's that make-peace scenario. I think that kind of section, those regs under the customs prohibited import regulations. But in any case, even if we do or don't, it doesn't matter if we assume that earlier provision applies or not. What do the facts tell us? Let's look at the authorised person's reasons for refusing importation. Look at the first reason he gives, or she gives.
Not a relevant consideration?
Okay, yeah. All right, yep. Okay, so what out of those facts raises that?
Well, it seems to be like his own personal opinion that those particular motions aren't what the Attorney General's Department should be facilitating. It's going to be grounded in policy. Yep.
All right. Let's look at that case. Minister for Immigration ex parte applicant S20/2002, and that's and the decision could be bad if it's irrational, illogical, and not based on findings or inferences of fact supported by logical grounds. So probably number one would come unstuck against that dictum I've just quoted.
Yeah.
Okay, what about number two? Activities of a nature to which the goods relate. Artistic, educational, scientific activities. As far as I can judge, the only relevant activities in which Wycliffe engages are of a purely superstitious nature. How does that wash?
Is that his opinion?
Yeah. And
because he said, as far as I can judge, it's like his opinion.
Yeah, that's right. So it's an opinion. Now, sometimes opinions are very well grounded, as we all know in life. Is that the case here?
No, not really.
Depends on the authorised person's qualifications, but it really seems to be a personal judgment again.
Yeah. Well, yeah, again, some personal judgments can be very well founded, but he's saying here that Wycliffe engages in stuff of a purely superstitious nature. Now, who is any decision maker to pass judgment on somebody else's religious beliefs? Because, religious beliefs aren't susceptible of rational inquiry when it comes to decision makers. How can a decision maker gauge whether one person's religious belief is valid as distinct from another's?
So is that a ground of taking into consideration irrelevant?
Yeah. It's also probably mischaracterization. If it's purely superstitious, well, so what? It might be animistic. It might, I have no idea. It's just one of those things. It's not. It's. I do a bit of work in the law and religion space, and certainly from other work I do there, the idea is that it's not possible for the courts to pass judgment on religious matters because they don't have the technical skills or theological training or ability to do that. So we know from other areas of law that it's simply impossible to gauge the truth of religious belief. It's not to say people shouldn't have religious belief. That's not the point. The point is, how can you gauge it? How can this decision maker say, oh, Wycliffe's superstitious, therefore I'm not going to allow him to import this product.
Mm.
Okay, so it's an irrelevant consideration. All right. Okay, now the other problem with number 2 is where it talks about the superstitious nature is go back to the ADJRA and have a look at section 5 sub 1H. And basically a decision is reviewable if it's based on the existence of a particular fact and the fact did not exist, i.e. the decision maker says Wycliffe engages in superstitious activities and there's nothing actually in the facts that indicates superstition at all. So you've got the problem then of a jurisdictional fact being asserted that doesn't actually come to pass at all. So it's that part of admin law that deals with for a decision maker to make a decision, he or she has to be satisfied about the jurisdictional facts on which he or she is acting in the very first place. So it's one of those things that I think would be problematic. Have a look at the case Rajamanikam.
51H, was it?
Yeah, 51H.
There's no evidence or other material to justify the making of the decision.
Yeah.
Yep.
Yeah, so have a look at the leading case is Rajamanikam, which is that 2002 High Court case. That's Rajamanikan, Rajamanikam. But it's not an easy test to apply. So have a look at para 58 in particular of that decision. Okay.
What para was that?
Look at para 58 of Rajamanikam. Now, just what I'll say is just a question for exam technique. Sometimes you might conclude that a particular ground of review, say, doesn't exist. To cover my backside in an exam, I'd also be saying, but if I'm wrong, plead in the alternative. But if I'm wrong, that, ground 51H doesn't apply. If it does apply, then deal with the alternative consequences. The decision is bad, it's infected by error, whatever conclusion you need to draw. So, generally speaking, for important things, argue both sides of the ledger.
Mm-hmm.
Okay. Now, if you look at point number 3, about Wycliffe's religious devotion, how does that sort of come into the mix?
Where does he get the well-known fact from?
That's exactly the point. Good pickup. All right, so what he's done is he's relied on a fact that's extraneous. Now, it's almost like we've heard of the doctrine of judicial notice. Courts can take into account certain matters that are just notorious. And now there's an equivalent doctrine in administrative law called the doctrine of official notice. And if you look at the AAT decisions, you'll actually see I wrote a decision on the AAT when I sat on it, where I dealt with the doctrine of official notice. I can't remember the case. So excuse me not remembering what I've said. But certainly there is a doctrine of official notice, which is similar to judicial notice. Anyway, I'm trying to remember what I wrote in a particular case. I decided there. I think I said that basically the doctrine of official notice, the facts have to be so notorious and well known. And there's really, but in this case, I don't think there's enough evidence to ground it, is my sense of it. All right, now, what do we make of number 4 in the decision maker's letter.
He must
Sort
want
of
the statutes.
defeating.
Yeah, sorry, Robin, you go on.
I was going to say he must want the statutes for himself.
Okay. Yes, it talks about it being displayed in the large display cabinet room in the George Knowles building, in the erotica room, whatever that is. Okay. All right, so they should go on public display. All right, so what's that, in terms of admin law grounds, what is that suggesting?
He's defeating his own argument against importation.
Yeah, well, generally, in a sense, he's taking the other side and arguing for it, but is the way he's doing it permissible or not?
Is that to him saying that even though he refused importation, but if they were to be imported, that's where they should be?
Yeah. Okay. Now, is that taking into account a relevant consideration, or is that an irrelevant consideration?
Irrelevant, because...
Yep, I agree with you. I think it's taking into account an irrelevant consideration, so therefore it's suggesting that the decision might be bad, or it's a ground to challenge it.
Is that like he's made his decision and he's got to the end and he's like having second thoughts?
Well, it probably is indicative of that, but the question is actually taking into account an irrelevant consideration that even if I imported it, it should go here. I mean, that's irrelevant. So in other words, because they're not going to allow the importation, therefore they're not going to put them on public display. But really, the whole thing is a furphy or an irrelevancy. What would
go to whether it's import though?
Yeah, sorry, go on.
Doesn't the whole decision go towards whether it is or isn't a prohibited import in the first instance?
Well, it is. It's well, what makes something prohibited is obviously the decision of a decision maker to actually allow or refuse importation. It has to be done on certain grounds, but the grounds that are given, such as they appear from the facts, seem to be pretty strongly indicative of some pretty wayward thinking, and that's what we have to take it up into our standard grounds of judicial review. And to my way of thinking, number 4 is just completely off the wall. It's irrelevant.
But I would see that as the core of the issue. Like, if it's not a prohibited import, then happy days, bring them in. If it is a prohibited import, then we make a decision on whether we'll allow you under these circumstances to bring it in. So if they haven't answered that question in the first place, to say I doubt, surely the first inquiry.
Yeah, I suppose the facts of this problem don't require us to actually debate the question, is this a class of prohibited import or not? I think we are to assume that the religious artefacts are prohibited for whatever reason.
Okay, fair.
Yeah, I think we take those as a given. Is the way I would read the problem. And then the question is are the actual reasons given all that convincing in a legal sense?
Yeah, fair enough.
All right, now, okay, we've touched on. So I'm just going back over. Now we've touched on each of 1, 2, 3, and 4. I think 4 is just off the wall if I was faced with that kind of thinking from a decision maker. Now, let's look at the third broad phase, and that is, aside from judicial review, are there possible alternative causes of action or courses of action by which Wycliffe may press his claim to be allowed to import the statutes?
Religious grounds?
Yes, possibly the arguing for the exercise of religious freedom, and therefore you still have to get over that hurdle, though, that we have to persuade this decision maker to allow it when her decision at the moment is to actually refuse it. So obviously we would put up some arguments about his religious freedoms being unnecessarily inhibited or impeded. Now, although it's technically not really part of our course, you could look at the Australian Human Rights Commission Act and the question of religious discrimination, and you might be able to construct some fairly sensible arguments to help you justify the importation on religious grounds. The other thing is, although this question focuses on judicial review, you might also go back in under the Customs Act as well and see whether you can, these articles may not fall within any specific prohibitions. And the other thing to do is you write back to the decision maker and ask her to rethink her decision because she seems not to have taken into account a whole bunch of relevant considerations. In other words, she may have got the wrong end of the stick about, for example, the artistic merit of the statutes and that it excludes them or doesn't. E.g. question number 1, devotion to cocaine, smoking, fornication, cannibalism and child abuse. For example, you might be able to show that those sort of things are not really what it's about. So you might, in a sense, debate the merits of not so much religious beliefs, but of the decision maker's understanding of those religious beliefs.
Isn't that a conversation you would have had before you got to this point, though?
Yeah, probably. Yes, sorry, it could be depending as to how much was said on your behalf or how much Wycliffe actually wrote. Certainly when I've been involved in making submissions to government bodies on, things of this, not this particular nature, but in general, I did a fairly complicated stamp duty matter about 3 months ago, and I ended up writing about a 20-page letter to the State Treasurer saying why certain exemptions should be applied. And they're the kinds of things you do go into an awful lot of detail about an argument about why something should be allowed. So yes, you're right, Terry. You would debate this right up front. But sometimes you can go back to the same decision maker and say, you've just got it completely wrong. Before I take you to court, you've got a chance to review all your stuff, and here's your chance to make the correct decision. So you certainly would see if you can go back.
Can I just go back to one point there?
Yep.
In terms of alternative courses of action,
yep.
If you could, instead of seeking judicial review on the decision maker's decision in this case, if you could go back and seek judicial review on the item being defined as a prohibited import, which, if that's defined, could
yep.
be argued as a question of law.
Yep.
If you could attack it on that basis and get it redefined so there wasn't a prohibited import,
yep.
The rest of this all falls then, doesn't it?
Yes, yeah. The objection would completely fall over. So that's what we call a question or process of characterisation. So if you can characterise it as other than a statutorily prohibited import, then there is no prohibition to its importation. Therefore, it should be allowed. There would be no question about it.
That might be a simpler, or that might be a preferable avenue, is to attack.
Well, yeah, it is. But you would also take the same thinking, though, Terry, and you'd apply it into the JR as well, because don't forget the JR regime, the statutory judicial review regime, says if there's an error of law. So whether something, let's say the legislation said all religious artefacts are prohibited. Now, if you could characterise these artefacts as, for example, artistic artefacts instead of religious artefacts, that's what we call a jurisdictional fact. And if you can convince the decision maker that the jurisdictional fact is other than what they think it is, then you might get a court to agree with you, and the court would say, well, it's actually a cultural artifact, not a religious one, therefore its importation is all right. So,
yeah, and then
yeah,
all
and
the
you
other
can-
problems.
sorry, and then go on.
But then all your other problems go away. Don't
Yeah,
they?
that's right.
Because
The rest of it falls off. It's all academic after that. So it's often the way you tackle the problem in the first place. In a sense, the first questions you ask about it often shape the approach you take,
Yeah.
and that's
So
a
would
big
you-
part of being the work of a lawyer. Sorry, Robin, I'll come back to you in a moment. A big part of a lawyer's work is trying to convince a decision maker, whether it's a government official or a judge or somebody else, that the problem isn't defined the way your opponent says it is.
Yeah.
Robin, you were going to say something?
I was going to say that if that was the case and someone said that to you, would the solicitor write to them first to try to get them to agree to import it? And if they said no, then you would take it to judicial review?
Yeah, yes, you would. Yeah, except most. Yeah, that's right. That would be a pathway. You always try and resolve things out of court if you possibly can. Just
Everyone's
remember
got to
that.
have their day in court, but
Well, yeah, there's a policy of liberal access to justice, and sometimes you just have to take things to court because you need a decision from somebody who's not going to get it wrong, or hopefully wrong.
most of the time you would try to write to each other to try to sort
Yep.
it out. Like
Yep.
say,
Yep.
like in the court where I sit, you have criminal offences, so you put in submissions to the police to try to sort it out first.
Yep.
If you can't agree on it, then you go to hearing.
Yep.
Similar
I've,
thing.
yeah,
Yep.
I've got one of those coming up in a couple of months. I'm acting for a guy who's got a move on direction under the Police Powers and Responsibilities Act. When I get the police brief of evidence in probably at the end of January, I'm going to write to the police and say, this case is so weak, it's not funny. You really should be withdrawing it so that my bloke doesn't have to go to trial.
And then,
yeah,
so that's like you do the submissions and then you say,
Yep.
if you take me to trial, then you're going to get costs.
yeah, that's exactly what I'll say.
is that for a breach of a move on order? Is it?
Yeah.
So is that like we had one where he was busking and he didn't move on from busking, something like that?
Yeah, it's not those facts, but it's he's a fairly well-known guy around Brisbane who does a lot of protesting. So yeah, he's allegedly not about to move on direction.
I'll have to keep an eye out for that one.
Yeah, it'll probably if we go to trial and gets convicted, we'll certainly appeal it. So it'll end up in the district court. So then it'll be a matter of public record. But yeah, but they're all the skills we lawyers that try and employ is you try and get cases resolved out of court as much as possible. Because
that's a cost factor, is it, as well for your client because of the costs?
Yeah, that's true. It's partly that. It's also a case resolved out of court. Ironically, for me as a barrister, it's counterintuitive. But if you can solve cases out of court, your people are much happier.
Yeah, definitely.
Because you don't have an umpire such as a judge or a magistrate telling you what the situation is. That often leads to more unhappiness.
I could agree with that one.
Yeah. All right. Any questions about the material we've covered tonight?
Just can I ask two quick ones? I don't
Yep.
know long. Instruments of delegation in
Yep.
terms of delegating to decision makers.
Yep.
Is there some requirement that before powers are delegated to others that they meet certain criteria? So the person to whom you delegate a power through an instrument of delegation must have certain criteria to enable them to discharge that power. Is that the case?
For some things it is. I was just thinking, for example, under the, I think it is the Social Security Act, the Secretary of the Department of Social Security or Centrelink, whatever it now is given authority to delegate. And then I think there are some actual instruments of delegation that set out as subordinate legislation what the criteria are meant to be. So often your governing statute sets out criteria. Sometimes it's in the regulations. So the answer is it depends, and it may be in a piece of legislation.
So some documents I sign have like delegate written on them at work.
Yep. Yeah, that's a illustration of a similar principle.
Yeah.
And just quickly, Simon, where the AAT has an appellate jurisdiction, like for something from, say, the SSAT,
Yep.
can you only appeal to the AAT as an appeal tribunal on a question of fact? You can't appeal on a question of law to them, can you?
Well, actually, you do. You actually appeal. They're both merits-based tribunal, one sitting over the other, and so when I used to sit on the AAT and heard SSAT appeals, you would be hearing them de novo, meaning that you're making a complete decision, and on both facts and law. So that's the beauty of merits review, is it's much broader. The higher level decision maker can make a decision what is the preferable or most correct decision to make on these facts. So you open the whole thing up completely.
So the AAT as an appeal tribunal can decide on an error of law, even though they're not a court.
That's right. They can. Yeah, and I often did. When I sat on the AAT, I sat on it for 5 years and heard appeals from lots of different bodies. If I took the view that the SSAT had erred in law, I would say they have erred in law, this is the legal error, and I'm going to make a different decision to the one below for, among other things, legal error, even though I wasn't sitting as a court.
So you don't have to remit it back to the SSAT?
No. Yeah, in fact, you generally didn't. You had power because of the way the system, the appeal structure worked, is you had power to actually substitute a decision and make the mantra in the case law was that we had to make the correct or most preferable decision on review. So we had an independent duty to make decisions. Sometimes when we would only remit stuff back to the SSAT when it required the application of facts that we couldn't determine. For example, for what length of time was this person supposed to get this pension or benefit? Sometimes that evidence wasn't in front of us.
But the SSAT, in its original jurisdiction,
yep,
you do a merit review on fact, can't they?
Yes.
They can't. You couldn't appeal to the SSAT on a question of law, could you?
No, and you wouldn't anyway, because what you were trying to do was to get them to change a decision usually about a benefit. Sometimes it may involve a legal error that someone in a Centrelink office got it so completely wrong. But basically, the merits review is to remake an administrative decision in its totality. So you look at law, facts, and mixed law and mixed facts.
But the SSAT can't decide on questions of law, though, can it?
No, it can't, but it would have to apply the law as it understood it. And the same thing for the AAT. The AAT couldn't per se make law because they're not a Chapter 3 federal constitutional court. So they couldn't technically exercise judicial power any more than the SSAT can't. But certainly once you take it up to the higher levels, it's a quasi court. It runs pretty much the same way a normal court does.
So if I've got a matter of Social Security, for instance,
yep,
and I believe that the department has made an error of law in determining my benefits, I can't seek review from the SSAT. I have to go to a judicial review.
No, you probably would, in practical terms, take it to the SSAT, because you would probably be able to persuade one of the three people sitting as the tribunal there that somebody had made a cock-up on the legal side, and therefore they needed to change the decision. Also, it's far cheaper. SSAT review costs you nothing. So if you can get them to make a changed decision in your favour, why wouldn't you?
Oh yeah, no, I've just got this. Yeah. I've just got this view that it's only the tribunals can only. Well, I don't know. It's only the tribunals can only. It's only the tribunals can only. It's only the tribunals can only rule on errors of fact, not error of law.
Yeah, they have to. It comes down to how you dress it up, or how you characterise the problem. You can always take merits review up to the next level, providing you have a ground to do so, and you always try and persuade the higher tribunal, the merits-based review tribunal, to make a decision in your favour. And one of the reasons you would try and persuade them is to say that the decision maker below made a legal error, and this is a chance to correct it, even though they're strictly not exercising judicial review type powers.
What about in the case of QCAT if you've got non-judicial members sitting on the panel?
Yep.
Can they correct an error of law?
The answer is yes, but they'll generally do it pretty badly, in my experience.
I'm not a fan of QCAT.
Yeah. No. Truth is, I shouldn't bag them, but a lot of lawyers hate going there. I've done 2 or 3 cases there this year that I wish to God had never gone there.
In QCAT court.
Yeah. Anyway,
we do a lot of QCAT, and it's just,
Yeah.
And then a decision in QCAT can't be enforced anyway. You've
That's
got to
right.
Register it to enforce them in another court anyway.
Yep. So, that's part of the drawbacks of a merit-based system. When you don't, that body doesn't have the power to enforce its own decisions. That's just one of the limitations of the system.
That's the same with any tribunal, though, isn't it?
Pretty much, yep.
They're not legally binding,
No,
are they?
No, they're not. But you generally find that most government departments won't ignore a QCAT decision. Sorry, if it involves a government department, that is. Not all of them do.
What about in civil matter QCAT? If you get a finding in your civil matter QCAT,
yep.
If they're just not going to comply with it, you've then got to go to court.
Yeah, you do. You always give someone a chance to comply, and then if they haven't complied with, then you might nominate
They don't put a time limit on them, do they? Most magistrates don't put a time limit on.
No. If the order, generally most QCAT orders I've seen will have a time limit. Say, the respondent to pay the applicant X dollars within 28 days, and then if you don't obey that, then the person wanting the benefit of that order then has to then take it through the MAGS court or the district court or whatever to get it enforced.
Because the QCAT's got no jurisdiction to enforce an order that's made.
That's right.
That's right. I know, I get them every day.
Yep. Sure.
I get people who try to get their money back and they can't get it. And they said, the court gave it to me, give it to me.
Yeah. One of the thankless parts of your work, I bet. Okay, any other questions before we wrap up?
No, that was great.
Okay.
No, but it's been good. It's helping me to understand. I'm struggling to understand, so I've enjoyed, even though I got on late.
That's okay. Late. Sure.
It's helping me to understand a bit better.
Good. All right. In terms of... Sorry, go on.
Sorry. Yeah, are we going to... are we going to do Mondays regularly, or is it?
No, it's a bit of a variable feast. With the license I'm using to get onto Zoom is actually shared with another CQU academic, so we have to tic-tac-toe all the time to figure out who's got that slot. So I will contact this chap tomorrow and see when he's got his next session on. So it might be Monday, but I can't guarantee it. I'll obviously post it as soon as I know.
Yeah, it's just a little bit of heads up is great, because sometimes if you don't find out until the day, by the time you get home from work, you have to.
Yeah, no, I can understand that. That's why I've been trying to flag it a few days ahead at least. Yeah, all right.
Yeah.
Okay.
Fantastic.
Okay. All right. Well, thank you so much, everyone, for participating. And sorry you won't see my happy face on video, but at least there will be an audio feed for everybody else. All right. Well, good night, everyone, and hopefully we'll catch you early next week. And as I said, I'll post the next Zoom session, and we'll probably cover problems 11 to 15.
Thank you.
Thank you.
Okay. All right. Good night.
Good night.